Good afternoon, Mr. Danji.
Hello, how are you?
I'm fine, thank you. I'm the court reporter. I'm just finding out, are you representing someone or you're just
Madam Court Reporter, he's the plaintiff in the case.
Oh, he's a plaintiff.
Okay, good afternoon, everyone. Welcome to Collier County Court. I'm Judge Martin. We have a matter for 1 o'clock today set for 4 hours, which is Gustafson versus Stevenson. Have I got counsel for the plaintiff present?
Good afternoon, Your Honor. Alan Hamish and Michelle Hurwitz from Hamish and Hurwitz for the plaintiff.
Okay, and is one of you going to be sort of taking the lead and doing the talking? Because I want to try to limit back and forth.
Right, that'll be me.
Okay, Mr. Hamish. And then on behalf of the Stevensons?
Yes, good afternoon, Your Honor. Jason Martorella on behalf of Ryan Stevenson.
Okay, Mr. Martorella, good afternoon. And I think I have plaintiff and both defendants as well as a court reporter. So good afternoon to all of you. Let me do this. I've got 3 individuals who I believe will be witnesses. Let me get you all sworn here at the outset. Would you all raise your right hand and I'll swear you all in? Do you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes.
I do.
Okay, very good. All right, and I think the 2 who are at the same residence now have separated in the residence well enough that you all can both be on separate devices and it's not interfering with each other. I think the Stevensons had the feedback loop. Okay, good. All right, and Mr. Martorella, you had filed a very late motion to amend and continue, and the court indicated that I would permit you to be heard at the outset of this hearing on that. Do you still wish to be heard on that? And if so, you may proceed.
Okay, thank you, Your Honor. Yes, I would like to be heard on it. So we filed a motion for leave to amend and also a motion for continuance. And the motion for continuance is based on several issues that have arisen since or been discovered since the filing of our last and operative pleading. And one of those issues, I think, requires a continuance, and that is the fact that the Sarah Stevenson is one of the tenants under the operative lease, which we didn't realize until we were preparing for the final hearing that the plaintiff didn't sue under the operative lease, never gave any notice to Sarah Stevenson, who has a leasehold interest in the property, never sued Sarah Stevenson, never served her with process. So to evict, to enter an order of eviction, granting the plaintiff possession of the property without Sarah Stevenson being named a party, we think would be depriving her of her due process. So, I mean, unless there's a judgment that's entered in the favor of Ryan Stevenson, it would seem that going forward today might create more work than it would eliminate. The second,
Can we take that issue and let me ask a dumb question, but isn't that Mr. Hamish's problem?
it is, and we alerted Mr. Hamish to the issue last week, and we thought that he would want to reschedule the hearing, but he's opposed it. So
He can't evict anybody he hasn't sued. So I don't know that that's a basis for me to continue to grant defense continuance. I don't know, Mr. Hamish, I don't want to step on your toes. Perhaps you want to continue and add parties.
Your Honor, thank you. Mr. Maratola talks about an operative lease. The operative lease is the one that was signed in front of my client specifically at the leasehold estate when Miss Stevenson was not present. It was Miss Stevenson has a possessory interest under the lease, but she's not a party. There are 2 leases and one of them was signed after the fact by the defendants.
Okay.
And
well, that might be part of the proof that we get into.
right, but my point is the lease, the operative lease is the one attached to the complaint.
Okay, and that's fine. If plaintiff is comfortable with the parties plaintiff has chosen to sue here, again, the evidence may take us in a different direction. I understand defense motion, but again, I see that really only as plaintiff's problem if it is. And that'll have to be part of what we will litigate here today, but it doesn't seem to be a basis to continue today's suit. So what was the next basis, Mr. Martorella?
Right. The next basis was that we've requested leave to amend, and this is based in large part on facts that occurred after our last pleading was filed. And those facts are just that, the property has continued to slip into a state of disrepair. There's continuing animosity between the plaintiff and the tenants. There are issues with the property that are impacting the health and safety of the tenants and their children. So they are actually wanting to now vacate the premises because of those issues. And we had alleged in our last pleading that the plaintiff breached the lease agreement as a defense. What we've asked in the amended pleading is that that the tenants actually be permitted to vacate the property without being considered in breach of the lease because the plaintiff materially breached the lease first. So I guess that's not a basis to continue this hearing as long as this hearing isn't deemed a final hearing, because we would still want that claim to be addressed at a subsequent hearing.
I was with you till the middle of that sentence. This is a final hearing.
Right.
I don't know what else it would be.
I mean, if it's a final hearing, then our position is that it should be continued until the counterclaim that is included in our amended pleading is at issue.
Okay. Mr. Hamish, your position on that?
Well, although the courts although there's case law that says that the court should grant leave to amend freely, it's when justice so requires. Here we are at the 11th hour. There's no basis for waiting until after trial was noticed, except to delay this. There's no basis. There's no amended affirmative defenses. It raises a claim that is not compulsory, so it can be filed in another case. There's no compulsory claim.
I was actually of the opinion that it is compulsory, but that it's really predicated on facts that were known at the time of the answer. I mean, the suggestion, Mr. Martorella, seems to me to be, it continues to get worse, it continues to be bad, but there certainly was plenty of alleged disrepair and animosity at the time the suit was filed and the answer was given. It felt to me like a compulsory counterclaim that was untimely. But do you want to speak to maybe what Mr. Hamish has suggested and what the court has suggested?
Right. I mean, I can speak to the timeliness. First of all, there are cases finding that even on the eve of trial, filing a motion to amend, a motion to leave to amend should be granted if justice so requires. But the reason why it was filed, one of the reasons why it was only filed until or last week was because Mr. Hamish scheduled this hearing without coordinating it with our office. We only had notice of it from Mr. Hamish a week ago. And the counterclaim is there, it exists. It is based in part on, facts that existed at the time that the last pleading was filed. But because it is a, valid counterclaim to bar, essentially, especially if it's a compulsory counterclaim, bar Mr. Stevenson from raising it, and because of a timing issue that was created by the plaintiff's counsel, we think would unfairly prejudice Mr. Stevenson.
All right. Well, on that ground, likewise, the court's going to deny the motion to continue and the motion to amend, and note a couple of things. I am not persuaded that there's anything new or different or that could not have reasonably been ascertained at the time of the answer. Again, it's just really ultimately, it comes across as a last second decision to counterpunch, and it does not comply with the rules in terms of timing. With regard to the timing issue, let me note a couple of things. We're in summary proceedings here. This is an eviction. This is probably the slowest I've ever gotten an eviction case to final hearing, and it's because I've got both counsel, and y'all haven't been particularly quick. When we got your communication fussing about Mr. Hamish's failure to coordinate, my assistant quickly forwarded me all kinds of emails where on January 5th, I think it was, she proposed to Mr. Hamish February 17th. And that date came and went without anybody getting back to us and accepting that date. So lots of time has gone by. It's summary proceedings. It's not a typical civil situation where we can go back and forth and say, nah, that date's not good for me. The court said this. Now, Mr. Hamish giving notice of hearing a week out is probably not as quick as I would prefer, and I'm relying on my memory, which is dangerous. I think Mr. Mortarella was copied on the emails back and forth with my JA, carving out these dates. So no one got sandbagged here. This is an expedited proceeding. The last second motion must fail under the rules, and I'm going to deny it on the grounds asserted so far. There was a final point with regard to a video that I think really might be more appropriately construed as a motion in limine. You, Mr. Mortarella, want to get a video. They've not listed it as something on which they intend to rely, but I understand your position being that I know they're not relying on it, because if I had it, it would undermine their testimony and prove my client's testimony. Do I have that about right?
Yes, Your Honor, that's our position, yes.
So, Mr. Hamish, can you speak to the video? Is there one, and why is that not in your exhibit list?
I don't know that there's a video. I have no intention of playing a video for the court. Even if there was one, there was no request for production of one. And so to say we didn't get a video, so we should have a continuance, is kind of a futile request, since we're not relying on it for the purpose of testimony or the court's taken into consideration.
I think if I understood Mr. Mortarella, it was only upon learning of the police report that he learned of the video. And I don't know what the timing of the disclosure of the police report might have been. Mr. Hamish, can you speak to that?
I provided the defendants the exhibit list the same day I provided the court the exhibits.
Okay.
So again, there's been no request for production of any kind. So all I did was provide my exhibits pursuant to trial order.
Okay. Mr. Mortarella, your position on that?
Yeah, I mean, we received a copy of the police report 6 days ago, and I understand there was no written discovery, but I also understand the procedures in the case to be that there is no discovery available except upon motion. And so we couldn't, I don't think, accomplish that entire, move for leave to propound written discovery requests, propound them, and then obtain a response between 6 days ago and today.
Okay, but the suit has been going on since November. That's
correct, Your Honor.
All right. Pretty unusual, over $3,500 being deposited every month. In this case, dragging on more than my average is right around 30 days. So I think what I'm going to have to do is just sort of take that, like I said, I construe it as a motion in limine. I think I take it under advisement and see how the evidence goes. I'm not inclined to continue the case, but it may be that the court's obligation to fairness may cause the court to have to limit certain testimony if it gets into a credibility contest and the video could have broken the tie. So I don't know that it's going to end up ultimately being a turning point from what I've read of this file, but it does not appear to be anything that, again, could not have been discovered with due diligence. I take as gospel the suggestion that these three folks had an encounter one day that caused the police to have to come. And usually if somebody's filming, they're holding up a cell phone the whole time, and it's pretty obvious they're filming. So I don't know, again, that this is a surprise, certainly not a basis to continue. I think we forge ahead. So Mr. Martorella, any other bases that the court needs to address? There have been 3: an indispensable party, a counterclaim, and discovery of a video. And on each of those, the court has denied the motion to continue. And on the counterclaim, I've denied the motion to amend to add that. Anything else that I need to address before we proceed with the final hearing?
No, Your Honor, and I appreciate the court taking the time to consider that before the final hearing.
All right. Let me just make a couple of notes on those threshold matters. Okay. Let me, before we start then with testimony, let me ask another dumb question. I'm good at them. I wanted to step back for just a moment before we drill down into all of the back and forth here. I'm certainly keenly aware, based on everything that's been filed by both sides, that this has been an unsuccessful landlord-tenant relationship. Really, on both sides, there seems to have been acrimony and discomfort and so forth. I did note, Mr. Martorella, in your motion to amend, a suggestion that, hey, we want out after all. And this is, I think, a 2-year lease, which also makes it a little bit unusual. But I can appreciate that attorney's fees are in play. I think probably a fair amount of fees have racked up because this has dragged on for quite some time. And I wanted to ask of both counsel if there was any opportunity or any interest in taking an opportunity to see whether there's any possibility of agreeing to something mutual here. And before I get an answer from you, I'll note there's a couple outcomes. I don't have the ability to split babies. So if I find ultimately in favor of the plaintiff, that means Mr. and Mrs. Stevenson would be out arguably within 24 hours. If I find in favor of Mr. and Mrs. Stevenson, that might mean arguably Mr. Gustafson, I'm sure I'm saying that wrong, has them as tenants for a whole other year. And whoever loses is not only paying their lawyer, but the other side's lawyer. So there is a very big swing between best case scenario and worst case scenario for each side. And from where I sit, in my experience, that tends to be fertile ground for a settlement. If you all could craft something, there is the possibility of a split baby. Everybody gets some of what they want, maybe not all of what they want, but they avoid disaster, they minimize expense. And most importantly, you drive your own destiny and craft something, however imperfect, better than your worst case scenario. Mr. Hamish, is there any interest on behalf of plaintiff? Have you all had some conversation about that on your end?
Your Honor, we haven't necessarily had any communication since as far as settlement, but to that end, I would be willing to mute and go off video and call my client individually and see if there is a possibility. As you know, I'm always available for settlements.
The breakout rooms are great for this, and the court reporter and I can stay in the main courtroom. I can do 2 rooms and have a plaintiff room and a defense room where you all can speak with total privacy, and then you could merge together the 5 of you to speak again out of earshot of the court, which is required and appropriate. And you could see if you can fashion anything. Or I can just put you in one and you can do, as you said, Mr. Hamish, just mute and telephonically communicate.
Maybe what we ought to do is if you can split us up, I'll get Mr. I'm sorry, I can't pronounce your name, Martorella's phone number. It'll give me a chance to talk to my client. We'll do a breakout and then I can call Mr. Martorella and say, make an offer if that's what my client wants to do. And then the only thing I'd have to do is figure out, I guess, can I raise the hand or something to get in touch with?
I think you can send message. You can also just come back into the courtroom
Okay.
You may also be able to reach me by chat. I haven't tried that yet, but I won't go anywhere. I'll be here. Mr. Martorella, are you interested in having the conversation to see if anything can be fixed here?
I am, Your Honor. I actually reached out about that a few weeks back.
Okay. Well, it's, you know, sometimes I appreciate it. It helps to, you needed an answer on your motion. You needed to kind of know what the cards on the table would be. And now everybody can see the whites of everybody's eyes. We will resolve this case one way or the other this afternoon. So I'm hopeful that with the benefit of a very solid counsel on both sides, that the clients will heed their advice and see if you can find middle ground. Like I said, all I can do is pick one outcome, and it's you all can pick something that's a blend. So I'll put you into 2 rooms. Before we do that, Mr. Martorella, do you want to give Mr. Hamish a good number and vice versa?
Oh, yeah. My cell phone's the best, 786-503-9523.
Okay, perfect. 9523?
Yes.
Okay, then I'll do a plaintiff room and a defense room and let you all get to it. I wish both sides good luck, and let's see if we can do that. If not, let's try to be prompt because we'll need our time this afternoon to
Right.
litigate. Okay.
Thank you, Your Honor.
Okay, accept the invitation. All right, the court will be in recess until they come back. Okay, good afternoon. Do you want to be on the record?
Not yet.
Okay.
So we've just been manipulated the last few changes.
Okay.
What we're going to do is I've electronically signed everybody's name on there without the attorneys. So on the record, when they come in, we're just going to have them, we're going to ask them if they agree to this, if they agree to their electronic signature.
Okay.
That way I don't have to change the time.
Okay. And I assume you'll want to do that on the record.
Right. That'll be on the record. So
Okay.
I just sent, we had like 5 words that needed to be added. I just sent it over. What I'm doing is I will send Anne the settlement agreement and a Word version of the order directing the clerk to distribute to release the funds from the registry.
Okay. Okay.
And just generally the provisions in the agreement allow them to stay until May 3rd. So we're
Okay.
going to keep the case open until that time.
Okay. That's fine. The only trick on that sometimes is the existence of an open eviction can make it hard for them to get housing elsewhere.
Yeah,
If they're okay with that, that's the only reason sometimes I've pushed plaintiffs' lawyers to let me dismiss and reserve jurisdiction to enforce, but it doesn't make a big difference to me as long as you don't sort of handcuff them from finding another spot.
Well, yeah, that was one of our discussions, but it sounds like they have a place. They just can't get in until
great.
the end of April. So
Okay. All right, and then are you going to e-file the agreement? I know you're going to courtesy copy it to Ann, but you want to e-file that, and then just I'll take the order in Word format and I'll get that filed.
yes, I will. Yes, that's exactly what I'll do.
Okay. Once we confirm that everybody's on the same sheet of music, then yeah, I'll ask you to upload that, and then I'll take care of pulling your Word order into my system and signing and uploading it.
I told my client to leave the breakout room. I don't know if he's still.
I can close the breakout rooms if we think everybody's finished with them.
Can you close my breakout room? Because I told him to come back in.
Let's see.
Oh, there he is.
There he is.
I'm back.
Okay.
All right. Do we think we can close the other room? It'll give them 60 seconds to rejoin us.
Let me call him real quick.
Alternatively, I can pop in there and check on them and see if they're ready.
I'm calling Jason.
I'm sorry.
Hey, do you want the judge to close your breakout room so everybody can go back in, or are you still talking? No more than 10 minutes? Okay. No, that's fine. I'm not in the breakout room anymore, so I'm just waiting on you. Okay. Thanks.
They need a few more minutes.
He's going over line by line with his client
Okay.
again.
I'm going to go ahead and go into recess then and wait until we've got both sides in the courtroom.
Sure.
So would you be more comfortable in the breakout, or you want to just stay where you are?
I'll just stay where I'm at.
Okay. If you and your client,
I'm going to turn my video off. So
I am too. If you and your client need to chat, just head back to the rooms. I don't really want to be privy to it.
We're pretty much done. He can call me on my cell if he needs to.
Okay. Very good. I'll be in recess until the other parties join us.
Thank you.
Mr. Martorella, are we ready?
Yes, Judge, thank you. We're ready.
Do you all want to be on the record at this point?
Yes, we spoke with Mr. Hamish and his partner. I don't know if they're on, but we agreed.
Let me hold, there we go. I want to make sure everybody's on then. So we'll start in just a moment and we'll be on the record. Okay, I've got both counsel. So Mr. Martorella, you may begin.
Sure. So we've reached an agreement with the plaintiff, an agreement between the plaintiff and both Ryan Stevenson and Sarah Stevenson. And we would like to continue on the record just for the purpose of executing the agreement because it's going to be done electronically.
Okay.
So I think with that, we would ask that, just the parties confirm that they've read and agreed to the agreement and authorize counsel to apply their signatures electronically.
Okay. And is it lengthy? Are there a whole bunch of terms or are there just maybe a few salient terms?
It's 6 pages, Your Honor.
Okay.
I just sent it over to Ann, but I think maybe what I can do is I can share the screen.
Okay.
And ask them if, we can put them on the record and
All right.
I don't know what I just shared. Hold on.
It's paragraph 15.
Oh, that's what, okay, sorry. It doesn't really show up on my screen what I'm sharing.
Right.
So.
Okay, that looks like the top of a settlement agreement.
All right. Judge, do you want me to do this or do you want to do it?
I don't want either of us to read every line of a 6-page.
No. I guess I was going to say, this is a settlement agreement you guys have entered into. Do you agree to the terms of this agreement? Are these your electronic signatures? Are you okay with, do you agree to have your electronic signature hold you to the terms of this agreement?
Okay. What I guess I was going for is if there are, say, a deadline to move out, an agreement that the registry money disperses to the plaintiff, and an agreement that, whatever those main terms are, I just wanted to have you summarize those.
Okay.
So that I know there's a ton of boilerplate and I'm not worried about that, but the guts of this thing, the salient points, I'd like to have the 3 litigants have that reviewed in their presence, in my presence,
okay.
And affirm that that's what they're agreeing to. So
then why don't I can go through the recitals of the settlement agreement in everyone's presence, and then sorry, Aaron. And then Your Honor can ask them.
Okay.
They're already under oath, so they can say yes.
And your client's got his video off, but at some point I'll need to see him so I know.
And can you unmute and put your?
There we go. Okay.
Okay. So Your Honor, the parties have entered into a settlement agreement. The terms of the settlement agreement are that the operative lease that we're going under is attached to the settlement agreement as Exhibit A, which is the lease agreement that was attached to the complaint. The parties agree that upon execution of this agreement, which is Exhibit B of this agreement, that their agreement that the court will distribute funds that are in the court registry. We have attached an agreed order on that.
Okay.
That the parties also agree that there are repairs and maintenance that need to be performed, and that upon reasonable notice, which is defined as 24 hours notice via email to Ryan at edencps.com, that repairs can be done between the hours of 7:30 a.m. and 5 p.m. And unless an emergency occurs, no repairs will be made or scheduled between May 1st, 2021 and May 2nd, 2021.
Okay.
The parties also agree that Sarah Stevenson and Ryan Stevenson will vacate the property with their minor children on or before May 3rd of 2021, leaving the property in broom-swept good condition and order. Further, the parties agree that that the Stevensons will continue to pay rent pursuant to the lease agreement, which is attached as Exhibit A to this settlement agreement, in the amount of $3,525, which is to be paid on the first day of each month until they vacate on May 3rd. The amounts have been prorated for the May 1st, 2nd, and 3rd in the amount of $113.17 per day, which comes out to $341.13 for the month of May. Security deposit will be distributed pursuant to Florida statute. The amount of security deposit is $3,100. And upon vacating, the parties agree to continue with the Florida statute 8349, which deals with how security deposits are distributed.
Okay.
There's a limited release for all claims that could have arisen or have arisen, with the exception of damages to the property, which can be brought up through the security provision.
Okay.
That within 10 days of the parties vacating the premises that Stevenson's vacating, that the plaintiff will file a voluntary dismissal with prejudice of all claims. And in the event of default, that the parties are able to pursue any action that they're entitled to. Specifically, though, there is a default provision that says in the event that Stevenson's fail to vacate the property timely or fail to timely pay rent, that Mr. Gustafson shall be entitled to an immediate ex parte final judgment of possession against the Stevensons, and that they're waiving any rights, any defenses to a writ of possession, and that Mr. Gustafson would be entitled to attorney's fees and costs from the beginning of this case in the event that they fail to follow through with those things.
Okay.
Everything else is boilerplate. The court has jurisdiction to enforce the agreement. There is an attorney's fees provision in section 11 that says if the court has to enforce, there is attorney's fees. Otherwise, it's boilerplate.
Hang on just one moment. I think my assistant may be calling. Give me just a moment.
She may be providing you with.
Okay, I apologize. That was IT. That was not Ann. We were in the process. You were mentioning attorney's fees, Mr. Hamish, and I couldn't hear the end of your sentence.
Just that attorney's fees in the event of enforcing the agreement. Everyone's waiving fees except upon breach.
Okay, so everybody's going to bear their own fees as long as it goes smoothly.
Yes.
Okay.
And
Anything else that we want to confirm both sides' understanding?
not from our side, Your Honor.
Mr. Martorella, anything else you want to highlight for the 3 clients before we ask them to confirm their consent?
No, Your Honor, thank you.
Okay, so Mr. Gustafson, as plaintiff, did you understand everything that your attorney just reviewed for me?
I did.
And are you in agreement with entering this settlement today?
Yes, I am in agreement.
All right, I think your attorney has affixed an electronic signature on your behalf. You consent to that, and that's a signature just as though you'd signed it yourself with a pen?
I consent Alan, my attorney, to represent me in my behalf in all regards.
Okay, very good. All right, and then let me ask Ms. Stevenson, same question. Did you understand everything Mr. Hamish just reviewed with me?
Yes, Your Honor.
And did you also have a chance to go through the actual agreement in some detail with Mr. Martorella before we came back on the record here?
Yes, extensively, Your Honor.
Very good. Do you feel like you understand exactly what you're agreeing to here?
I understand. Yes, ma'am.
Okay, I won't require anybody to be happy about it. I know settlements necessarily mean everybody gives up a little something that they wanted, but I just want to confirm, are you willingly adopting this agreement and based on the electronic signature, does that reflect your actual consent to this?
Reluctantly, but yes, willingly. And I
Good.
give our lawyer, Jason Mozzarella, consent to sign on my behalf.
Very good. Mr. Stevenson, same question. Do you understand everything that's been discussed here?
Yes, Your Honor.
Did you go through it very thoroughly with your attorney when you had the chance to speak with him privately?
Yes, ma'am.
And do you consent to, do you agree to adopt this settlement as your agreement?
Yes.
And you consent to the application of an electronic signature here to reflect your consent to the agreement?
Yes, Your Honor.
All right. That would be everything I would ask. Mr. Martorella, anything else that you want to place on the record?
No, Your Honor, just my thanks again for your time today. Thank you.
Sure. Mr. Hamish, anything else that you would like to place on the record or colloquy any of the three individuals?
No, Your Honor.
Okay. And so this agreement has been sent to me. Let me just grab that. Okay, I have 6-page agreement with the 3 electronic signatures, and then there's the attachment of a lease, 13 pages. I'll just scroll through that quickly. Okay, and that is the lease. It looks to be the lease that was attached to the complaint, which bears only Mr. Gustafson and Mr. Stevenson's names on the first page and on the signature page. It's just them. Ms. Stevenson is not a party, and that is the lease. I think, Mr. Hamish, that you indicated the parties are agreeing to be bound by going forward.
Yes.
Mr. Mortarella, you agree that attachment's correct?
That's my understanding of the agreement. Yes.
Okay, and then I've got this proposed agreed order that the funds would go to Daniel Gustafson and the mailing address would be Mr. Hamish Business. Let me just take a quick look at one other thing. Okay, and that's the same order that came to me in Word format, so I will get that executed promptly. I think that's everything. So as soon as we hang up, I will sign off on the order.
Your Honor, I just filed the settlement agreement right
Okay.
now.
Do you want me to add a sentence to the agreed order that ratifies the agreement? This just deals with the registry funds.
Yes, Your Honor.
Okay. Mr. Martorella, you okay with that?
Yep. No objection to that, Your Honor.
Okay. Just makes it a tiny bit tidier. Might not matter one way or the other, but I'll add a sentence there and get that order filed. And generally, Mr. Gustafson, the money is usually mailed by the clerk within about 10 days. And you'll stay in touch with Mr. Hamish about that. If
Thank you,
there's
Your Honor.
if there's nothing further, then I'll let you all adjourn. We took up just about the same amount of time, but neither side had to suffer a disastrous outcome. So I'm grateful to all of you for your diligence and perseverance. I know this whole thing's been unpleasant for everyone, but I promise you it could have been worse. This is an imperfect but good outcome, and I'm grateful for your hard work, everyone.
Thank you,
If we're all
Judge.
set, I'll
Thank you.
conclude the hearing. Good luck to both
Thanks for your
sides.
time.
Thanks.
Thank